Okay, so I'm going to share my slides.
Amanda, I wanted to let you know really quickly, if you have any polls, they're not going to work in the breakout rooms. So just in case
I
that's
Okay, thank you.
part of
I
it.
do not have polls today.
Okay, perfect. And I will keep an eye on the chat for you while you're doing your presentation.
Okay. I'm trying to find the right screen with my presentation slides. Okay. Is that coming across for everybody? Okay. Well, like I mentioned, our law firm does a lot of estate planning, long-term care planning, and guardianships. And so as I was thinking about how to present the material today, I thought about it in two groups. One are what are the decisions that we need to make to help support the person? And so we think about decision making authority in general and powers of attorney and guardianships and conservatorships and that when are those legal tools useful for helping to support the people in our life, friends and family. And then we also, we also think about the property that we have and how we want to help protect benefits and we want to help protect assets over time because for every single one of us, the care and the resources that we need, they just cost money. And so we want to make sure that we are taken care of, our friends and family members are taken care of. So we've got some tools that we'll go through there about how to think about money and assets that will help support people who are on public benefits or other planning strategies. So when I think about the legal system and how it interacts with long-term care and just making sure our needs are met, one of the central ideas is capacity. And every single one of us are stronger in some areas and weaker in other areas. If you're really autonomous and you're really strong, quite a bit about a topic, or just you're able to learn and receive new information. You can understand different alternatives that are available to you. You can weigh risks and you can communicate decisions. There are some areas of my life that I would say I'm pretty autonomous about. I can make decisions without a lot of extra help. There are other areas of my life that I would need some support in order to make a good decision because I don't have either the skill or the understanding of that area. And so I would need to reach out. I need to find somebody who could provide some advice or help me make a plan, help me express what it is I want to do. And then in other areas, even if you were to explain cryptocurrency to me, I probably am just not going to get it. It's just not my forte. So, um, if I lack capacity in an area, it doesn't matter how much information is shared with me, I just cannot receive it. I cannot understand it. I can't make choices. I can't really assess the risks. Or somebody who lacks capacity can't communicate what they would like to have happen. And so I wanted to just emphasize that this is really a continuum and that each of us are somewhere along this continuum at any given point in time, but it's dynamic and it changes over time. And it changes depending on the type of decision that we're talking about. And so it's really kind of a fluid concept. So there's different strategies depending on the kind of decision that we need to make and where we are along this continuum. If I'm autonomous, then really I'm going to make a plan, but it's a plan that's kind of central around what's the unexpected. Here's what I want to do. What's the plan B in case something unexpected happens or something goes south? I want to be in communication with the people around me and the people who are in my support system. I want to look for advice from people who know more than I do or who are experts. And I'm probably going to want, as my legal tool, I'm probably going to want at minimum some powers of attorney. That'll help me if I get into an accident or something does happen, that means I've got a backup person who can step in and help make decisions in the case of an emergency. But I wanted you to see that no matter really where you are on this continuum, you kind of need the same elements. You need a plan that's going to help cover the short-term needs as well as the long-term needs. You need to be communicating with the people in your support network, your family, your friends, your care providers, and getting advice from time to time to make sure that you understand what are the changes to the programs, what are the changes to the laws that might have affected your original plan. You want to get advice, and so it's really kind of that legal strategy at the bottom that might change depending on where you're at in life and where you're at in terms of capacity. If you need some support, maybe powers of attorney is still going to work for you. You still are able to communicate well enough who you want to be your support person, who you want to help make decisions about your medical needs or care needs or your property. And between that and maybe having a more formal supported decision-making plan, that will cover most of the emergencies you'll face and meet your needs well without having to take away your ability to make decisions into the future. But if the need is there and the capacity is low enough, there might be a need for a guardianship or a conservatorship. But even within a guardianship, there's still some decisions about what are the areas where this person might need help making a decision or expressing their decisions. And is it across every possible decision? Do we really need a full guardianship, or can we tailor it to just meet the needs of that one person? If you went to the breakout session, if you went to the breakout session earlier where they were talking about the legislative changes that are coming through, there is a bill that has been proposed to change the guardianship statutes, and that bill kind of addresses the spectrum more specifically and puts into the statute more of the supported decision-making options than what's currently in the statute now. But as I go forward and talk about the guardianships and conservatorships, I'm mostly just talking about what is in the law right now. So the first legal tool you may have come across is durable powers of attorney. And I'm going to go through some of the key elements of powers of attorney, and these elements are the same whether we're talking about a medical power of attorney and decision making over care and our medical decisions, or a durable power of attorney that's more focused on property decisions. The principal is the person at the center of it all, the person whose decisions are being carried out. The agent is the person who has the authority to help the principal make their decision. So they are, it's sort of like an employee or somebody who's just been delegated the ability to carry out the will, carry out the decisions of the principal. The powers are the actual decision-making authorities or activities that the principal is going to give to the agent. And you can also add to any kind of power of attorney limitations or special instructions. So when is this power of attorney effective? When is it not? Under what circumstances can this person act? Maybe they can only do certain kinds of things. Like I had a client who was really concerned that their agent not give away a set of collectibles that they had. And so they wanted to write that into their power of attorney, that this meant a lot to them, and under no circumstances was the principal or was their agent supposed to get rid of this collection. When we talk about durable powers of attorney, the durability means that there's not a set time limit, that this document, this legal document, is going to be effective unless the principal dies, or there's a brand new power of attorney that's written and it cancels out the old one, or if there's some specific instructions that say, if this event happens, this is no longer effective anymore. And for anybody who's going to step in and act as an agent, there's some legal responsibilities here. You are to act loyally to the principal and act in their best interest. Your job is to act with care and competence and diligence. So if you're helping to make decisions for somebody else and part of what they're doing is, they might be in the hospital, they may not be able to manage their finances. And if you need help doing that, you need to hire an appropriate professional, or you need to go seek some advice to make sure that you're competently handling their property. You should keep records. You don't have to turn those records into anyone necessarily, but if the agent gets asked, hey, why did you make this purchase, or what happened to this money that got transferred out of the account, or why did you make this specific decision? It's good to have some records to show that you weren't doing things in your best interest, but were doing them in the principal's best interest. So as I mentioned, the durable power of attorney, that's the common name. That's a legal document giving decision-making authority to someone else over property. And the healthcare power of attorney is delegating decisions about care and the person. Fortunately, there is a really great resource that's on the screen right now. They're called the statutory forms, and the Idaho legislature has actually written some sample forms into law, and those have been translated into documents that are available through Idaho Legal Aid, and they have some additional resources and training materials there, as well as the actual statutory forms for powers of attorney that you can go look up. You might want to draft a special provision for your power of attorney. And so you can also work with our law firm or any other law firm, any attorney, to draft a specific, more customized power of attorney. And depending on the needs that you're trying to meet, I can say we often will draft some language about whether or not the agent has the ability to do things like seek out psychiatric treatment for somebody, or move somebody from the state of Idaho to another state if there's not an available treatment option in the state of Idaho. So where you have some kind of specific needs that you want to address, it's nice to have some custom language in there so that there's no question that the principal, the person who's delegating decisions, is saying that they want their agent to make this kind of decision. So we're going to compare and contrast a bit the difference between the powers of attorney and a guardianship. With the powers of attorney, the person at the center, the principal, they still are able to make decisions. Their decision-making authority hasn't been taken away from them. And that means that they can even change who their agents are. They can take away the powers of attorney altogether. They still have decision-making authority. Whereas under a guardianship, a court has said that this person cannot make certain kinds of decisions, and so the guardian or the conservator, their decisions override the protected person's decisions. So the principal under powers of attorney can change who their agents are, but under a guardianship or conservatorship, if you want to change those decision-making supports, you have to go get a court order. Anybody can be an agent if you are an adult and you have you still have legal capacity, you can be an agent. If you want to be a guardian or a conservator, though, you have to be an adult with capacity. You will go through a background check where they'll look to see if you have any felony convictions, and if you do, that is can get overridden, but generally is disqualifying. You'll have to go through a specific training, and then the court will have to find that it's in the protected person's best interest for you to be the guardian or the conservator. There's also some priorities that are written out in statute. So if you're lower on the list of priorities, you will maybe have to explain to the court why somebody higher on the list isn't acting as guardian, or why you are in the best interest of this person. The powers of attorney can just be terminated in writing. There's not anything, as long as it's in writing, there's not additional legal steps necessarily that have to be taken, whereas a guardianship or conservatorship needs a court order to terminate. There's not formal reporting on the powers of attorney side, although if the principal or another interested person wants to ask you some questions about the decisions you've been making, they can. But in a guardianship or conservatorship, there are annual reporting requirements where you're actually turning in documents to the court to explain what kind of care you've been providing for this person and how you've been managing their finances. And in general, the powers of attorney are much less expensive, not only to set up, they're very low cost to set up and to maintain, whereas the guardianship or conservatorship is more expensive. So there right now is legislation drafted. I think it's passed the Senate and now it's in the House side of things. That's a pretty extensive rewrite of the guardianship statutes. And one of the goals, I believe, of the rewrite is to protect people's decision-making authority and to try to put in statutes stronger language about finding the least intrusive alternative or the least restrictive alternative. Even under a current Idaho statute, though, there is that courts are directed still to ask questions about this. Have you tried powers of attorney first? What else has been done, and why is a guardianship or a conservatorship the appropriate solution for this specific person? So before filing anything, you would want to try some of these other options if those would be at all possible. Once a person is under a guardianship, there are certain kinds of decisions that you'll have to get a court order before you can make. So there are certain decisions around reproductive health, specifically birth control, that you would need to get a waiver from the court before moving forward with. Same thing for experimental medical treatments that requires a court approval, and certain end-of-life decisions. If we live in Idaho, and if the protected person has been enjoyed family hunting trips or has firearms of any kind, there are federal laws that would limit their ability to possess a gun, and that's been interpreted even to the extent to say holding a gun. So if you're a family that enjoys hunting, that's something that you would want to think about. Guardianships and conservatorships are more expensive, especially if you have them over a long period of time and there might be changes, several changes over that person's lifetime. And again, they're less private because there are some, while those records are not public, you still have to provide to a court an accounting of the decisions that you've made, either for their caretaking or for their property. So when we talk about what is the actual legal requirement, what are the legal definitions for finding, or for the requirement of a guardianship, there's different kinds of guardianships. This first kind is a guardianship for an adult who lacks capacity. So this comes up a lot where we have sudden cognitive impairments like strokes or car accidents, or perhaps different types of dementia diagnoses. Then you'd probably wind up under the guardianship statute for incapacitated adults. And what the court is really looking for is, can this person communicate what they would like? They're looking for functional limitations. So there's no one specific diagnosis that's going to guarantee the guardianship necessarily. They're looking at, how does this type of diagnosis affect this person's ability to take care of routine care tasks or understand differences between choices? And is their inability to make decisions, is that going to cause actual harm? And is this a pattern of behavior that has happened over the past 12 months? So it's not, I got really drunk one night and now no longer can make decisions for a short period of time. It's there's a pattern over an extended period of time where this person is not able to make decisions. And for conservatorships, the court is looking for, can this person manage their property, or is their property or assets at risk of being wasted? And the wasting is not necessarily just they're not good with money, they're not making good decisions, but it's, for example, they just are really, this protected person might be really prone to being taken advantage of by people they've met online. And so they've transferred large amounts of money to strangers, or they'll enter into contracts not understanding and having been taken advantage of by somebody else. And so it's kind of that scale or that type of waste. And then there's other type of guardianship under current Idaho code is a guardianship for an adult with a developmental disability. And that has a really specific definition in code, and that means it's a chronic condition with an extended need for care that shows up in this person's life before the age of 22. And the statute gives some different types of diagnoses that it finds would fall under this category, but any condition that has similar treatments would fit the definition. And then they're looking, again, for functional limitations. It's not just that you have this diagnosis, but it's this diagnosis in this person's life means that they functionally are significantly limited in being able to take care of themselves, or in mobility, or in communicating their needs, these different functional areas. And then I have on the right-hand side of the page, you'll see these bench cards. These are publicly available, and these bench cards are a nice kind of summary of what the rules are for both types of guardianships. And this is what judges are going through as they're trying to make these decisions. They might have them just right up there on the bench. That's why they're called bench cards. And they serve as a nice checklist to kind of make sure that you understand what are all of the different things the court is looking for as you're trying to explain to them why a guardianship is necessary. So there's some different findings depending on the type of guardianship you're looking for. The processes are a little bit different too, and I can go into more detail about that if there are specific questions, but that's the high level of guardianships and conservatorships and powers of attorney in the state. So the next, maybe at this point, I'll just stop and see, are there questions that would be good to cover?
I did have a couple questions in the chat. The first was if you could talk a little bit, if you know, about what the changes to guardianship are in the proposed bill, and will the bill changes have an effect on guardianships already appointed by court order?
So the bill won't have impacts over past guardianships, but it might alter like reporting requirements going forward. I haven't delved into that part more specifically, but if you already have an established guardianship or conservatorship, that's not going to undo those. So where it might come into effect is if you need to make changes in the future, or if there are some different reporting requirements from this point forward. There's a lot of process and kind of finer changes throughout the bill. I think at a high level, the biggest changes are trying to put more emphasis on, is a full guardianship really the best solution for this person? Or have we tried supported decision making? That looks like a plan that you have with a group of support people in your life. And I mean, frankly, I'll say this from a different perspective. Guardianships are a legal determination on who gets to make decisions. It doesn't solve a lot of logistics problems. So if, for example, you have somebody under a DD guardianship, a protected person under a DD guardianship, and they might be living in an independent living facility, and they want to date, you might have the legal decision making over who they have contact with, but that doesn't necessarily solve the logistics of, this person wants to start new relationships. They want to meet people. If you tell them no repeatedly and they don't have a way to constructively meet new people, they might find other ways to meet new people, and that might be more problematic. It might be more secretive. It might be higher risk. And so I think what I appreciate about the law is that it's kind of, I think, in a way, a nice bridge into not just being more thoughtful about how much decision making we're taking away from somebody, but also trying to emphasize what is the plan to, maybe this person just needs some technological supports, or maybe they need, maybe they would agree to, before I start a new relationship with somebody, I'm going to use this person as my trusted friend, and we're going to talk about this before I go somewhere, or when I go out, here's who I'm going to be working with first. The range of possibilities is really broad because the range of needs and abilities is very broad. And so I appreciate the emphasis on trying to be more, trying to find the right solution for the right needs for the right person. And it recognizes the variety of options, I think, better than the current statute does. But I'm still learning about all the different procedural ways that might change things, and so I would be happy to do a separate follow-up presentation once the bill passes and once I know more on how the courts are actually going to implement the new processes. Are there any other questions? Okay, then moving into this second half, where we're talking about benefits protection. Why is it important? And then what are some different, some examples of different strategies out there? I won't spend a ton of time on the next two slides, but I'll just show them because this is part of the reason why it's important. If you have somebody who has special needs or enhanced needs, or who's going to need lifelong support, they are also likely to need public benefits of some kind, Medicaid or otherwise, and it's expensive. And so you want to preserve some money for them to last a lifetime. Sometimes we work with guardianship clients who are families with a person with a developmental disability diagnosis, and the parents get guardianship when the person's in 18, 19, but they've got 60 years potentially of life where they might need some support, and that doesn't, and the parents are probably not going to be with them that entire length of time. So how do we provide the supports that they're going to need over quite a long period of time? And under Social Security rules or Medicaid rules, the asset and income limits are so restrictive that it would be very difficult to try to accumulate a nest egg for this person without having it disrupt their public benefits. And so these strategies are important to both meet the eligibility requirements and also try to stretch resources throughout a person with enhanced needs throughout their entire life. So with the Medicaid eligibility, there's income restrictions. If you are on the basic health insurance, it's around $1,800 a month at this point. But if you need enhanced long-term care services, it's $3,000 a month. And then the asset limits haven't changed in a long time, and it's $2,000. And there's some changes if you are a married couple, what that means. I'm happy to go into a longer explanation on that, but it's that $2,000 is a hard limit, and it's $2,000 on the first day of the month. So if you have income and it's starting to build up and you don't have any other strategy in place, at least make sure you've spent it down so that the first of the next month you have $1,999. Not every item is an asset that gets counted for eligibility, and so here are some examples of different assets that if you have money in a certain kind of account or a certain kind of trust, that doesn't get held against you, and we'll talk about those in a moment. Every person in the state of Idaho can have one primary residence that's less than $750,000 in value, and that is including any mortgages that are on the home. So it's the market value of the residence minus any mortgages that might be on the home. You can have a vehicle of any price, but only one per person. And I think the other exempt asset that I like to point out is the income producing property. So let's say you had a primary residence, and it made sense for you to move from that house to go live with another family member. So this first property is no longer exempt as a primary residence, but if you turn it into a rental property and it's income producing, it is exempt if it's helping to support you through income. So one of the kinds of accounts that are exempt as an asset are ABLE accounts. These are accounts that are set up for a person with a disability, and you can establish that you have a disability either by qualifying under SSI or SSDI, or you can get a medical provider to certify that you have certain severe functional limitations. And there's a form that's on the ABLE Account Resource Information Center. I'll provide that link in a second, but there's just a form that you can have your medical provider fill out. The disability onset needs to be before the age of 46, and this is great because it used to be 26, so this is the first year that got bumped up. 2026 it gives you 20 more years of eligibility. Once you have established that the disability showed up before the age of 46, you can start an ABLE account at any age. So some kinds of accounts have to be set up before you turn 65, but the ABLE accounts don't care about when you start the account, they just care about when the disability showed up. The benefits are the money that's in these accounts are not countable as a resource for Medicaid or Social Security or any other federal means-tested benefit. It's tax-free income and distributions, and I can go into that a little bit more, but if you're investing that money, you're not taxed on the increase in the money that's in the account, and then if you use that money to buy something that is a qualified expense, then that distribution is also not counted as income for federal tax purposes. And these are pretty easy to set up, and they're pretty cheap to set up. So I will, on this slide, there's two different resources that are awesome, that are great. You can go to the National Resource Center and compare types of accounts across different states. You can open an account in any state, and you can open them online. You can only have one account, though, per person with a disability. So you can't have 5 different accounts in different states, just one account per person. And Idaho just started its own ABLE account, and That's new as of 2026 as well. Some things to know before you go opening one of these accounts is that these accounts are subject to Medicaid payback. That means anything that is left over in this account when the person with a disability or the beneficiary, when they have died, anything left over is going to go to that state's Medicaid, up to the amount that Medicaid has paid for services for them. If you have enough in that account and the Medicaid expenses were lower, if there's money after Medicaid's paid back, it can go to whomever the beneficiary has said they would like it to go to. So it can go to family or friends or anyone else. Anybody can contribute. So the person who is the beneficiary, the person with a disability, they can put their own property into this, and friends and family, anyone can put money into it. There is a limit on how much can be put in each year. So it's $20,000 in 2026. This number goes up each year. It's tagged to the federal gift exemption. So it goes up a little bit each year. If the beneficiary, the person with a disability, is working and they don't have their own separate retirement account through their job, they can put more than this $20,000 into the account. They can kind of treat it as a retirement account. In total, though, you can have $100,000 in this account. You can put more money into it, but it won't be exempt. So there's only $100,000 that is not counted, and so you would want to keep it below that amount. The qualified expenses are medical expenses. They're basically any kind of expense that the beneficiary might have, so long as it doesn't undercut any public benefits they're receiving. So where you would want to watch it is if it's going to affect, if they're on SSI and you're using some of this money for housing, will that lower their SSI payments because of an in-kind contribution of some sort? If you're on food stamps, you'd want to be cognizant that if you're using this for food, that might be considered a contribution and might lower your food stamp monthly payment. So you don't want to do something that's going to undercut a benefit they're already receiving. The hope of this type of account is to extend the supports that they have over a longer period of time. Another nice feature about an ABLE account is that the beneficiary can be in control of this account. So if they have the ability to manage finances, or even if they have the ability to work with somebody, a support person, to spend money, the beneficiary can maintain some level of control over this account. So generally how it works is it's a little bit like an education savings fund. You put money into the account, it's going to get invested, and it's going to be a managed investment account. And then when you're ready to spend money, you can transfer that money onto, it's almost like a prepaid debit card, and then you can spend up to whatever you've put on that card on the expenses that you have. And like I said, it's one account per beneficiary. Are there any questions about the ABLE accounts?
There's a couple questions in the chat. One person wanted to know, would something like an Xbox or TVs, things like that, count as assets? And then
No,
the other question is if you could just go over what might happen to the funds in the special needs trust after death.
Okay, I'm going to talk about the special needs trust next. So I'm going to put a pin in that question. And then the first question is, if you buy an Xbox or a television, is that a countable asset? It is not, because it's a personal item. So they don't count personal property as an asset that you have to like add up every item in your household. Okay, so the trusts are, there's some things about special needs trusts that are kind of similar to an ABLE account, but then there's some really key differences too. So in general, a special needs trust, it's a legal agreement between three types of people. There's what is called the grantor. That's the person whose property is going to be put into the trust. And then there's the trustee, that's the person who's managing that property. They do not have to be the same people. And then there's the beneficiary. That's the person who's going to get the benefit of the assets in the trust. So sometimes if a family is setting up a trust, especially if it's something like a revocable family trust, the grantor, trustee, and beneficiary might be the same person until that person dies. But these special needs trusts are not like that. We have a specific rules about who can be the grantor, who can be the trustee, and who can be the beneficiary. In general, there's two different kinds of trust. There's what's called a first-party trust and a third-party trust. First-party trusts are talking about whose property is going into this trust. A first-party trust means that the person with the disability, it's their money that's going into the trust. A third-party trust is somebody else is going to make a gift to a person with a disability, and it's a third-party property that's going into the trust. Both a first-party and a third-party trust are exempt for Social Security, Medicaid, and means-tested public benefits. They both require a disability that is documented. You don't have to be getting Social Security, but you do need to have documentation of the disability. If I'm a person with a disability and I get an inheritance from grandpa and he just gave that property straight to me and that was so kind of him, but now I'm going to get kicked off of all my public benefits and I'm under the age of 65, I can open up a first-party trust and put my own property into that trust. And that will save me from having all my benefits disrupted. If grandpa doesn't leave the money straight to me, but instead he says, I would like to leave money for the benefit of Amanda Bartlett, and I leave this money to the trustee of her third-party special needs trust. He never actually gave the money to me, he gave it to a trust. And so that's a third-party trust, and it can get set up no matter how old I am. And it has some different rules on the back end that make it really nice and probably the best, more ideal option of these two choices. In either kind of trust, whether it's a trust I set up with my own money or it's money that somebody has given to a trust they created for me, either way, the money has to be used for a person with a disability and only one person. So it's generally you're not setting up a trust with 5 different beneficiaries. You have one person who has a disability. They are the sole beneficiary of that trust. In both cases, first party, third party, it's a non-countable resource. Here's a major difference though. If it's my money, and I'm the person with the disability and I've set up a trust for myself, when I die, Medicaid will recover up to the amount that they've provided me assistance. That's the first party trust. If grandpa leaves me money in a separate trust, that's a third party trust and Medicaid cannot recover from that trust. So it's not part of my estate, so they can't come after it. In both cases, when the trust is going to provide assistance, there are rules very specifically about it can't replace public assistance, it supports public assistance. So it supplements, not replaces. So it's kind of meant to if the main support is the public benefits, it comes up underneath and will pay for things that those public benefits will not pay for. Medicaid at different times has paid for dental services. They may or may not into the future. If you can't get dental services, then this trust is a great option. The trust can pay for it because Medicaid won't. These trusts can be used to pay for travel. They can be used to pay for personal items that you might need. They can be used to pay for a private room in assisted living facility or a nursing home. All kinds of things to help enhance quality of life. both of these trusts have to be irrevocable. That means once they're set up, they're not supposed to get changed. And the main point of that is we're not going to set up a trust so that this person qualifies for Medicaid and then change it and gift that money to some other person. So the things that are really irrevocable are who is the beneficiary, and if it's a first party trust, you're not going to change that Medicaid is the first to get paid back. That part is set in stone. You can maybe make some changes to who the trustee is or some minor amendments to help it stay compliant with law, but the main bones of the trust stay in place. And again, the first party is the person with the disability. It's their own money. So it's not just money I have in my own private bank account. It's money I have a legal entitlement to. So again, if grandpa dies and he wants to leave me money, and in his will it just says, I'm going to leave Amanda Bartlett $10,000. It doesn't matter if that $10,000 ever hits my bank account. I have a legal entitlement to it. It's my money. So we work with families a lot to put language into their wills and their estate planning documents to make sure that you're not leaving money directly to somebody who has a disability or who needs public assistance or who might need Medicaid someday. You want to leave it to them in a trust. If you have a legal settlement of some kind, so if you get into a car accident and you get a legal settlement, that's first party money. That's your private money. If you're negotiating that settlement, you can try to put some language into it or see if there's, you might sometimes can get a court order that would allow for it to be third party money, but it's just any money that I have a legal right to. Before we go to other strategies, are there any questions about the special needs trusts?
I do. I was going to try to put it in the chat, but I can't do it quick enough. So
Yeah,
is the Medicaid recovery, that's only after that special needs person would pass away that Medicaid would go after that account?
that's right. So Medicaid will come after, they'll send you a statement saying roughly how much that person has, how much the Medicaid program has paid out for that person. And they'll put a lien on that person's estate through the Secretary of State's office. And if they own any property, land of any kind, they'll put a lien on that property. If it's a first party trust, there's language in that trust that explicitly says Medicaid gets paid back first. And so they'll already be aware of that trust and will seek to recover from that trust.
Okay. Can I ask one more question?
Yeah, absolutely.
So I obviously need to make an appointment with you on a professional level. So if my special needs child, well, adult, is going to inherit along with other grandchildren eventually, none of that trust language was put into that will that I'm aware of. Can my husband and I set up a third party trust in her name where those funds would go, or no?
No, you got to work with the family members to put that language into their estate documents because it's their money. They have control over what happens to it. And so they have to put the language in their own documents about how they are going to gift it to this person. And so
Okay.
it's worth,
Okay. Yeah, I'll need to make an appointment with you because now we
okay.
have like grandparents that have dementia. So I think it's probably too late to go back in and change language unless the person that has power of attorney would have legal course to do that. So I
Yeah,
don't
I would
know. That's
say
too messy, like a rabbit trail. I'll make an appointment with you.
yeah, that would be good. I mean, it's a situation that comes up, and in that case, it's going to be real fact specific about what kinds of changes can be made. So it's certainly worth getting a consultation for sure.
Okay, great. Thanks.
Yeah.
And one more, I have a question just to clarify with regard to the third party trust. Is Medicaid entitled to that money?
They are not. Sorry, I didn't mean
Okay.
to cut you off.
Nope. That answered my question.
Yeah.
Is there ever, sorry, finish your comment.
Yeah, absolutely. So with a third party trust, that's the best benefit of it, right? Whatever money is left over in that trust when the person with a disability dies, it can go to other family members, it can go to that person's children. It's not subject to estate recovery, but you have to follow the rules of that trust. The number one rule of that trust is there's no money in that third party trust that belonged to the person with a disability. So let's say they're kind of accumulating a lot in their checking account, just because they're not spending it as fast as maybe their Social Security payments are coming in. And they're about ready to go over that $2,000. So we'll transfer some of that into this third party trust. Do not do that. It can transform that third party trust into a first party trust, and then it is subject to estate recovery, and it's just messy. So you want to honor the rules of the trust to keep it away from Medicaid. You can have multiple trusts though. So this is not like the ABLE account. You can have a first party trust, and you can have a third party trust, and you can have an ABLE account. You can have all three. Unlike the ABLE account, you can have several third party trusts. It's maybe not the most efficient. I would try to maybe funnel it into a single one because it's just easier to manage, but you can have multiple types of trusts. And the bigger thing is just if it's a first party trust, they don't really care whose property goes into the first party trust. Medicaid's going to take it all anyway, so they don't care. If it's a third party trust, they really care a lot that it does not belong to the person with a disability. Because if it belongs to them, it's part of their estate, they'll try to recover from it. If it doesn't actually legally belong to them, then they can't come after it because it's not their property. It's not the person with the disability's property.
Okay. So one other question, Amanda. Like, what's the best thing to do when they get like lump sum payments that, like, when the pandemic payments came and hit their account, and it's just like, well, crap, well, how do I gonna do with all this money now? And not that, we weren't grateful, but or like I just heard a story about somebody who got like multiple years of back payments from Social Security that they didn't know they were entitled to, and this gal's client got 62 grand that then they had to. Is there one thing better than another to do with like a massive lump sum payment that immediately puts them over the limit?
Okay, so I would say a couple things. One, it's going to be very fact specific and based on the needs of that individual person, like what I would say is the best option, because I don't know, it depends. But in general, the options you have is one, you can buy an exempt asset. So you could use it as a down payment for a property and turn it into an income property. You could use it to buy a vehicle. You can spend it. If you're going to spend it, the rules are I think you have 10 days to tell Medicaid that it's coming, and then you have to tell them what kind of your plan is, and then as long as by the start of the next month you've spent it and they have less than $2,000, you should be okay. Another option is the ABLE account. So if it's less than $19,000, or $20,000, excuse me, you could open an ABLE account and put it all in there. And then you have kind of the rest of that person's life to spend it. You could use a first party trust. The nice thing about these trusts too is whereas the ABLE account can only hold cash, these trusts can hold any kind of asset, cars, residences, land, property, whatever, any kind of asset. And there's no dollar amount limit. So you could put, if they got $60,000, you could do a first party trust. They'd have the rest of their life to spend it. So maybe they don't have a lot of other income that's ever going to come into them. It's sort of a windfall lump sum, and they're 40 years old. Well, you have until you pass to spend it, and then whatever's left over will go to Medicaid. But there's a decent chance you can probably spend it over a couple, 10 years or so.
Thank you.
Yeah.
What banks can you go through for the ABLE account?
Those banks can be found on those two websites that I put in the PowerPoint presentation, and I believe that the presentations are going to be made available to people. So you can go to the ABLE account National Resource Center or the Idaho ABLE account, and it's a managed account through them, and so it's whatever bank that you have agreements with. It's a little bit like the ideal college savings plan in that way. You're not
Oh,
taking.
okay. So it's not even like a bank that we bank at personally. Okay.
No.
Okay.
It's like a managed investment account, and you can spend money out of it, but it's not something that you go open up at KeyBank.
Okay. All right. Well, that's good to know. Thank you.
Welcome. I think we're at the end of session. If there's any other questions, let me know. I will say at the end of the presentation, I have my contact information. We do free consultations, and I'd be so happy to chat